Okay, time's up. I hope you have a fully fledged ABS regime ready now.
We have.
You have? I had no doubts that the group where you, Harry, would sit as a legal advisor, a consultant, etc. So I would suggest that first every group reports back like 5 to 7 minutes. Hopefully that is enough. Then we give the chance for immediate questions to the group. Otherwise, the next group follows, and we will continue like that. So, who is volunteering to go first? Okay, the government of Mongolia.
Thank you very much. We divided the task into 3 portions. First of all, we thought about legislation related to access, then moved on to benefit sharing, and then moved on to the compliance. Thanks to our legal representative, we've come up with a range of issues, and I'd also invite him to jump in as well to help. First of all, we felt in relation to access, one of the first issues was to clarify the ownership laws. So from the role play we had this morning, we felt that it wasn't really clear where we were in relation to resource ownership and how we dealt with nomadic peoples and all those sorts of issues. So that was the first issue that we felt needed clarification. There was also another issue related to the permits, that we had no legislation that talked about the distinction between commercial and non-commercial uses, so we felt that needed to be clarified. There was also a need to think a little bit more about Article 88.1. We felt that that needed a renewal clause. So that was about permit duration and termination. And so in terms of that, the access to the resources, we felt that legislation was needed to add the opportunity for renewal clauses to that. Another issue that we flagged was also the fact that we need guidance on that recognises subsistence uses. So it's all very well for access to be provided to for a company to gain access to a resource, but during that process we also recognise that the community needs to think about subsistence use, and that subsistence use needs to be guaranteed. And then another area, moving on then to benefit sharing, we felt that some legislation was required that would actually outline the different types of benefits that were available, again referring to the commercial and the non-commercial benefits. Benefits such as the research use and the potential technology transfer, that type of thing. Another area that we felt was required legislation was to enable the government to act on behalf of communities where necessary. So if there were communities that perhaps hadn't got a great deal of experience in this area, then perhaps there would be a need for the government to act on their behalf and to set up a fund. But again, if that happened, then there would be need to be criteria for the use of those funds. And we had a bit of discussion about how one would actually assess bona fide benefit sharing arguments too, so that we might need some guidelines on that. And in relation to that, we'd also need to define the role of the government. So to ensure that if the government did step in, it didn't overstep its role. Then moving on to compliance, we felt that legislation to provide the opportunity for traditional knowledge to be recorded within a government-maintained database would be useful. And then that would allow patent offices to go back and search for the knowledge. So when they're issuing a patent, they can then see, well, is there any traditional knowledge related to this issue? And so then that could trigger compliance mechanisms to make sure that appropriate access and benefit sharing agreements are in place. But we stressed that that should be a voluntary recording of traditional knowledge, not necessarily mandatory. Then another area under compliance was the need for dispute mechanisms. So again, I think in the role play we'd all recognise that there wasn't necessarily any mechanism to resolve any disputes coming out of it, so that was an issue that needed legislation. And one of the recommendations under that was that perhaps access and benefit sharing agreements should only be agreed with countries that have already ratified the Nagoya Protocol, because otherwise you don't have any mechanisms to go back and resolve your disputes. And then finally, to underpin all this, we felt that there was a need for requirements that to encourage multi-stakeholder capacity building, to ensure that governments, communities were all able to deal with the legislation and to implement the legislation appropriately. And then I'll ask my co-workers whether there were other things to add.
Okay, thank you very much. Any questions? Maybe also from the LC's group to this group? Any questions from any side? No? Not yet? Before I respond to some of the issues, I would like to give the LC's first the opportunity also to present their ideas, maybe some of the issues captured there.
The first issue we had is with Article 25, the very first sentence: legal ownership of real property is vested in the person in whose name the title is registered on the Central Land Register. Now, that is inconsistent with the practice of ILCs. Many of the times they own and identify with the land simply because they have been there. That's where they were born, they bred, that's the land that they know. It's not all the time that the property is already registered in their name. So that can be a loophole that can be used to deny the communities their rights. Part C, still under 25, if the owner of the land has leased out the land, then in addition to the lease of interest over the land itself, the lessees need to have joint property, proprietary ownership of interests in all pre-existing biological resources. Now, this is tricky in the sense that at the time of leasing land, the terms are about leasing land, perhaps for a totally different kind of use, maybe farming or anything else. If at some point the lessee discovers that there is gold under or some very valuable biological or genetic resources above, this lessee then automatically gains 50% of the value of that resource. That is an opportunity to once more deny the communities well-deserved gains from such kind of resources once discovered. And therefore, the terms of lease should remain as they are and should not deal with any resources discovered after the lease has been signed. Then there is 25 part 20, down there, the last paragraph under 25. This is a law, I think, in a number of countries. If a person has utilized land for 10 years, then he automatically gains ownership of it. This can be dangerous once more because many times the ILCs are not very well informed of these provisions, and it may be used to actually take land from indigenous communities. Now, let's look at article number 84. We look at 84 and 83 together with 87. First of all, 83 and 84 provide for the access permit. None of them mentions the question of consulting communities, which is already a loophole. Then when you come to 87, it continues to reinforce the role of the Central Land Register and still fails to mention the communities. Then further down in part 2, there is the question of consent will be deemed to have been obtained if it is given by a representative of the community. While that ordinarily is a good provision, the question will be how to validate the legitimacy of this so-called representative. I think some imposters may come in and basically collude with the government or the investors to take land from communities. Then Article 25, Article 85, back to 85 actually, that is the last point. Communities, again, are excluded when it comes to providing the results. Yeah, sorry, I should be referring to Article 86. Again, there is a problem of excluding local communities there in granting access permit. So those are the points, unless any of you members wants to.
Okay, thank you very much. Any reactions from the government side? Any objections? Questions, misunderstandings? You're nodding, Eric, or no?
Yeah, I was also referring to.
Right.
They seem reasonable. I think they need to ask the government see if it's reasonable. I mean, I think they seem reasonable to us. We would want to promote the values of local communities, but would most governments be reacting in that way?
That's a good question. Government representatives here. No. Yeah, I mean, that's true.
I was just going to say, it goes to the heart actually of lawmaking in general. I mean, so few times do you see the development of law in a truly participatory way. It's often, you get a very, very almost finalized draft that goes out. Then there's a commenting period. Perhaps the comments are taken on board, perhaps they're not, and then that's the law right there. So I think this dialogue is very interesting because it actually highlights the absolute key to how you develop good laws, i.e. laws that have been developed through a participatory, fully transparent, open process, and it probably gives a pretty good inkling into why so many laws don't work in the first instance for most of the people to whom they apply.
You want to react? No? Okay, just a few thoughts or points from my side. Of course, I think let's start with the indigenous group. If I understood you correctly, you were not satisfied with the involvement of indigenous local communities in permit processes, right? You were arguing that their consent was not required, because if you look at Article 87, actually, it requires, it says a permit applicant whose proposed access would require access to a resource located on the land owned by an indigenous local community as recorded into the central land register shall obtain the consent of such landowners, and if granted shall enter into benefit sharing negotiations. So with regard to access to the resources and benefit sharing, there is, this consent foreseen. However, the problem is actually, and that is something that you both identified, of course, that property rights issue, because although it is, probably going much further than many other countries, giving, the possibility or providing for the possibility of co-ownership, it, has also some weaknesses. For example, and I think you identified or you referred to the issue of 10 years they have to utilize a piece of land in a manner that is consistent with ownership for more than 10 years. Another issue was that, or is that, at least the nomadic people, the nomadic community, might have a problem in verifying or providing a verifiable description, including any artificial or natural boundaries, in order to, get registered in the land, in the central land register. And that is the requirement, the basic requirement actually then for having ownership rights. And that also then refers to their right to be involved in the permitting process and the benefit sharing negotiations. So that is the kind of a problem there. Of course, there are also a few other issues with regards to property rights. One other important point that I think both of you actually missed, especially probably the government that could have jumped on that, was there was a provision on protected areas payments to National Parks Fund. And although this could be interpreted maybe already to foresee that monetary benefits flowing from ABS, could go to by financing of national parks, or this national, or contributing financial resources to this National Parks Fund. As this is foreseen, actually, not directly foreseen, but Article 9 of the Nagoya Protocol encourages countries to provide for investment or dedicating or direct